KZSU-FM Stanford, welcome another edition of Hearsay Culture on the Hearsay Culture Network. My name is Dave Levine. I'm a professor at Elon University School of Law, as well as an affiliate scholar at the Center for Internet and Society at Stanford Law School. Artificial intelligence is all the rage, whether we like it or not, and policymakers are in the midst of trying to figure out what to do about it. And in that vein, I'm very excited to have on Ellen Goodman, who is the Senior Advisor for Algorithmic Justice at the National Telecommunications and Information Administration of the U.S. Department of Commerce, on leave from Rutgers Law School, where she was the co-director of the Rutgers Institute for Information Policy and Law. And that's how I got to know Ellen years ago, with our mutual interest in information transparency and accountability. But now Ellen is in a different capacity related to that work, but focused on, as the title suggests, how we will go about attempting to regulate artificial intelligence, which has entered the fore for the public on November 30th, 2022, when OpenAI released ChatGPT. The NTIA is an executive branch, meaning president branch, for those of you that are not lawyers, entity, and it works with a variety of other government agencies to try to harness expertise around these issues. We're going to be discussing today not only the status of ChatGPT, but really the status of generative artificial intelligence, which we discussed recently with Cornell professor James Germelman on Hearsay Culture, and these broader questions of how policymakers can deal with these issues. We are quite familiar now about 5 months or so, 6 months into playing around, I'll put that in quotes, with ChatGPT, that its capabilities are astounding, even to people that are not are well versed in technology, but also quite unknown. There are enormous potential benefits, enormous potential drawbacks. But here we are in this space. And so in real time, we are trying to figure out what to do about it, which raises all kinds of policy challenges aside from the substance. And so that's what we're going to be talking about today with Ellen, who is in the midst of this work right now. And we are recording on May 31st, 2023. Ellen, thank you for joining us on Hearsay Culture.
Good to be with you, David.
So let me start off. For those that aren't familiar with the various entities within the federal government, tell us a little bit about the Department of Commerce, and then more specifically about the role of the NTIA as it relates to artificial intelligence.
Sure. Well, I will take them in that order, because a lot of people don't know how vast and varied the Department of Commerce is. And just with respect to AI, you know, it's interesting to note that the Department of Commerce probably is the largest holder of data in the world. If you look at the census, which sits in the Department of Commerce, and also at NOAA, which of course has been using AI for a long time to do weather forecasting. NTIA its statutory mandate is to advise the president on telecommunications and information policy. A lot of people know NTIA for its work on sort of managing federal spectrum, and then more recently on the broadband, handing out broadband grants to implement the Infrastructure Act and other broadband grant programs. Our shop, OPAD, does policy development, and so has been working in privacy, cybersecurity, emerging tech for a while. And so I was brought on to focus on algorithmic systems and AI. And, you know, where the rubber hits the road, NTIA is not a regulator, does not have the power to regulate AI. What it can do, and what we're hoping to do, is to provide very actionable recommendations that sort of go beyond some of the abstract adjectives and nouns that you know, the ethical, responsible, trustworthy AI communities are throwing at the problem, the risks, and the opportunities that AI presents. So our aspiration is to provide very concrete policy recommendations.
And so that's an important distinction, particularly for non-lawyers. a non-lawyer hearing that would say, what do you mean you can't regulate AI? I thought you're the government. So can you describe that difference between, let's say, the NTIA and the Federal Communications Commission or the Federal Trade Commission that does involve itself in regulation in a different capacity?
Sure. So, I mean, at the most general level, there are independent agencies and executive agencies, and we are an executive agency. So my boss, Gina Raimundo, sits in the cabinet. And so, we serve at the pleasure of the president. That's the first thing, whereas the FCC and FTC are independent agencies. But more to the point, some agencies have rulemaking authority, the FCC being among them, and they are authorized to promulgate rules, which have the force of law. There's lots going on there at the Supreme Court about how much they can sort of create policy. And then there are, the FTC has currently less space to create rules, but what it does is it's a law enforcement agency. So it enforces. So there's rulemaking, creating rules to sort of guide industry from the start, and then there's law enforcement at the back end to enforce existing law, and then there are kind of advisory positions in the government, which is what we have, which is to guide, and we guide policy not only in the executive branch, but are also asked pretty often by Congress to provide sort of assistance on legislation. And one of the things about, so right, I think you're alluding to the fact that we're in this kind of cauldron right now where there's a lot of interest in AI and there's a lot of calls to regulate AI, and we're actually seeing a lot of, at least sort of a couple dozen state and local laws and ordinances that are coming into effect that regulate AI. Some not very good, some not very effective. And so we have an eye out on those. And so where we can be helpful, I think, is kind of in elaborating upon and defining various kinds of regulatory interventions. And so that anyone, any state, local, federal entity can pick from those in a modular way in order to regulate.
This cornucopia of federal agencies that are involved here is quite remarkable. And I don't want to put you on the spot, but people might be surprised how many different entities other than Congress, of course, and the president, might be involved in AI regulation. We've mentioned a few: the FTC, the FCC, there's your executive agency, and there are others. The Office of Science and Technology Policy, for example, which is also within the executive branch, has a role here. Are there others on top of the four now that we've mentioned?
Yeah. So, I mean, and one of the things maybe we'll talk about, Dave, is kind of, is AI just a tool, or is it something else? And so to the extent it's just a tool, if you're using AI in your hiring practices, then the Department of Labor and the EEOC have something to say about it. Because they're looking at the outputs of the system, and just whether, if AI is used in it, that may sort of complicate their job, or it may lead to specific guidance. But what they've been very clear about is that, it's illegal if you do it without AI, it's illegal if you do it with AI. And we can say the same thing about, medical devices, which the FDA is looking at, or the Department of Education has just released a report on AI in the educational sector. So every single agency that has, we think of as kind of vertical jurisdiction over a sector of the economy, over a sector of society, to the extent that AI is active in that sector, that agency is going to have a piece of this.
And yes, it does get to that point, which is the tentacles that AI touches. Let's get into that, and we're chatting with Ellen Goodman of the NTIA on KZSU-FM, Stanford, and Hearsay Culture. It's really a kind of a fundamental question still to define what we're talking about. So what is your operating definition of artificial intelligence, and then more specifically, generative artificial intelligence?
This is a very contested question about how do you define AI, and what I'm learning is that it's the OECD definition, the sort of international definition, is what most governments, including the US government, are trying to harmonize their definitions with. And I'll just paraphrase it. I don't have it in front of me, but essentially it's a machine-based system that is capable of making predictions, recommendations, according to some set of human constructed parameters that operates with a certain degree of autonomy. So that's a mouthful, but essentially it's saying it's a machine-based system that is doing things humans usually do, make recommendations, predictions, and it's doing so somewhat autonomously. So there is a place for human supervision, and even things like ChatGPT, of course, have human supervision as part of the training and post-training process, and we can get into that. But the systems also are kind of iterating and using machine learning. So it's common in AI systems to be using machine learning, though not required. And so there's a mix of autonomy and human supervision. Now, that's not a very satisfying definition. And so, what you will hear in this space is a lot of wrangling over whether that's over-inclusive, includes too much, does it include an simple Excel spreadsheet, or a simple algorithmic, decision tree or flow chart. Is it too broad? And then there's another sort of line of attack, which is that this really isn't about the technology per se, exactly what the technology is, but it's about what it affects. And so one of the things that, if you look at the administrations, you mentioned the OSTP, they were the authors of this, a blueprint for an AI Bill of Rights. They don't get into this particular definitional battle. They just say it's an algorithmic system that's used to affect kind of important life opportunities for people. So that's another approach, is to look at the use cases rather than the specific technological features.
People that aren't lawyers at this point might say, oh boy, we got two lawyers now arguing about how to define something, which we enjoy as lawyers and we have fun doing in law school, but which others might find confusing. But this really does matter, right? I mean, it does matter how we define this, and perhaps you could explain a little bit why these definitions matter in this space.
Well, I think the definitions matter when these definitions become part of the architecture of regulation. So they really don't matter that much if we're just talking about, I don't know, our social media recommendation algorithms, is that AI? What's the difference between AI and generative AI? I mean, those are fun conversations to have, but they don't really matter until you have a regulation or a law which has to define it. And so, I think the reason why they matter is, one, you want to be covering the right kinds of things. You're imposing costs often when you regulate. If you're talking about a small or medium-sized business that's going to have to comply with a regulation, you might be affecting innovation and competition. And so you want to be sort of careful and precise about your coverage. You want to cover, you also too want it to be future-proof. So you want a definition that's not going to be so tied to technology as we know it today. We see how fast it's moving, right? That's not going to capture what should be captured tomorrow. And you also sort of want the entities to know whether they're regulated entities, to know whether they're captured by it or not. So to have some sort of certainty about who and what is covered. I guess there's a fourth reason too, which is that, and we can see this happening already. The EU is regulating, states and localities are regulating. We don't want, 500 definitions of AI that are conflicting with each other and 500 different requirements. So there's a sort of a harmonization ideal here too.
Well, I want to turn to the bigger points in a moment, but to frame our discussion around the regulation. Exactly what you just said is something I wanted to come to, and since you mentioned it, I'll mention it now. Privacy law in the United States is a mess. Privacy law scholars would say that, but the reason why I say it is that there is no unified privacy law in the United States. There's a variety of privacy laws around every health data versus personal information versus biometric data, and on and on and on. And anyone that has to deal with confidential or private information in the workplace or comes across it knows this. Are we headed in that direction, or is there a risk of that happening in the absence of something like not only unified law, but a unified definition of what AI means? Because, and I don't want to get into it here, privacy, even though it's obviously that term's been around for centuries, is not well defined. And there's debates around what privacy means. So are we running the same risk up front by struggling with the definition?
Short answer, yes. And longer answer, this is my personal view, and it's also the view of my agency, is that the lack of a federal data protection law in the US is not only problematic in all the ways you described for privacy and data protection, but it is also a problem for AI regulation. And so, these things overlap a lot. There are also ways in which tools that we might want to create, and whether it's self-regulatory or mandated, we might want to proliferate in order to reduce AI risks. And it's some of them are difficult to implement if you don't have some baseline privacy and data protection law.
We're chatting with Ellen Goodman of the NTIA about AI on KZSU-FM, Stanford, and Hearsay Culture. So before we get into some of the slightly weedier areas, let's touch on a couple things right up front. Almost on a daily basis, we're hearing either pronouncements of AI solving all the world's ills, or conversely, and this happened just a couple of days ago, right? A public statement saying from the industry itself, more or less saying this is an existential threat. Where do you put, and I know I'm asking a hard question, but I'm going to ask it anyway. Where would you put AI right now? In other words, it would seem that AI is not an existential threat right now, at least to the extent that all AI can do that we've seen is put out text, right? So it can tell you to do something or tell you how to do something, but it can't necessarily do it. On the other hand, right, so in other words, the risk that AI is going to cause World War III in the 1980s war games kind of milieu is not possible. At the same time, the grand solutions to problems also seem equally fanciful, at least to the outside observer, in terms of being able to create creativity in such wonderful ways that not only is it better than what we get as human beings, but also gives us more opportunities as humans to do it and so forth. I'm assuming that neither of those poles to you are really where we are right now. And I guess that's my first question. Either the existential threat, the end of days kind of concept, or it will solve all the world's ills.
Yeah, and I don't think it's like necessarily productive to sort of to put ourselves on a scale on either in achieving or sliding into either particular pole. I do think there are, and we've seen already.
Why is that? If you don't mind me asking, why is that unproductive in your view?
Because I think, just to take an analogy that's not perfectly apt, but when cars were invented and we had like the combustion engine, some things were known and some things weren't known. It was known to have a lot of safety risks. Maybe it wasn't known that the CO2 produced by the combustion engine would end up contributing to an existential risk of climate change, although that turned out to be true. But it was known that there needed to be traffic laws that weren't in effect. Like, for example, driving on one side of the road and stopping at stop signs or stoplights. So those things were created, but it wasn't known that cars would totally change the landscape and create, suburbs and have a whole kind of land use planning implication. So when you have a new technology, I mean, and obviously cars also, created lots of opportunities and mobility. And so there were benefits, there were downsides, there were risks known and longer term risks unknown. And so, I think, so I don't think it's useful to say, okay, well, and as you know, there's a very vigorous debate right now going on about should we even think about existential risk, and this is sort of existential for human beings in the case of AI. That's what they're talking about. Should we even think about it, or is it just a ploy of kind of the big companies so that we take our eyes off of the existing harms, near-term risks? And I just think it's more useful to focus on the continuum of risk, some of which we're experiencing right now, others of which may be a bit more in the future. Also to focus on the continuum of benefits, some of which we're experiencing right now, right? So AI is helping people enormously right now. And it's also, I think
how so, if you don't,
how so?
Yeah, I mean,
So,
where is it happening right now? That was going to be my next question.
yeah, I
I'm
mean,
interrupting your answer, but go ahead.
a couple of the big announcements, right? DeepMind's sort of decoding this protein folding mechanism that apparently was a very sort of a wicked problem, right? And that, I think, I'm not an expert in this, but experts say is going to open up all kinds of scientific innovation. Text to voice happening right now, obviously it has labor implications, which is another thing we can talk about it, as all efficiencies do, and it's a huge issue. And I would put that into the category of risks of the systems being used appropriately or in an expected way, right? They create efficiencies, and that will completely disrupt the labor markets, in painful ways that we better be prepared for. But in any case, there also, obviously, there's a benefit to that, so that, for people who need to have things read to them, it is instantaneous and cheap. And then, customized lesson plans, just sort of different kinds of learners can get curricula that's tailored to them. I think there are lots and lots of benefits, even, obviously we're all having fun in sort of trivial ways, and in some cases problematic ways, as we can talk about in the legal area, playing with ChatGPT. But so lots of benefits. Translation, huge, right? Huge game-changing benefit. And then risks, I think that, and this is something we're hoping to get comment on, and I'd very much, I'm curious about your ideas and also James Grimmelman's ideas on this, because mine are nascent, but I do think that the near-term or existing risks have a lot to do with control, transparency, a chain of responsibility. And I also think those things are implicated in the long-term existential risks. And so, it sort of feels like we're at this moment where if we can get governance systems in place to deal with the near-term existing risks, we will be much better off in dealing with the long-term or longer-term existential risks. They're not necessarily two totally different baskets of problems.
We're chatting with Ellen Goodman of the NTIA on KZSU-FM Stanford and Hearsay Culture. For those of you that listen to Hearsay Culture regularly, it's on KZSU, which is a nonprofit, non-commercial radio station at Stanford. Please reach out to us and go to our website if you'd like to make a donation. And also check out hearsayculture.com for the soon-to-be launched Hearsay Culture Network. Let's turn a bit here, Ellen, towards not only the framing of the problem, but also how policymakers are viewing it. So the Senate Judiciary Committee a few weeks ago, as you know, had a hearing on AI, and it was very interesting to hear the senators really speak for the first time formally about these issues. And so it was a remarkable hearing in a lot of ways, and I commend listeners. It's only 3 hours, which by congressional standards is a drop in the bucket, but it really was a power-packed 3 hours. So I highly recommend it. So I want to play for you. Actually, I play two clips, both from Senator Durbin, Dick Durbin, who in his opening statement frame the problems. I'd actually like to ask you to answer them, at least, within the confines of what we have here. So let me play his first statement, which he sets up in an interesting way.
1989 was a historic watershed year in America because that's when Seinfeld arrived. And we had a sitcom which was supposedly about little or nothing, which turned out to be enduring. I like to watch it, obviously, and I'm always marvel when they show the phones that he used in 1989. And I think about those in comparison to what we carry around in our pockets today. It's a dramatic change. And I guess the question as I look at that is, does this change in phone technology that we've witnessed through the sitcom really exemplify a profound change in America? Still unanswered.
What do you think? I thought it was very interesting to draw this parallel to, aside from Seinfeld, right, to the phone. And the phone and you just alluded to it in the context, right, of cars creating suburbs, the phone creating these different changes. What is your response to what I think is a rather philosophical but very important question for policymakers?
Yeah, I mean, it's a great point. And I think we can all say that the phone did entirely change our communication system, our political, I mean, it didn't change our political system, but it changed how we do politics. Many people would say for the worse. I think we're right now in a moment where maybe 7 years ago, we were focusing more on some of the benefits of the digital realm and digital platforms and the app economy. And, we've been through this period of techlash where we're focusing on some of the ills. AI, I think, obviously nobody can predict, as they couldn't then, where we will be. But I think it's sizing up to be as revolutionary of a change. And I don't know, I heard this on some podcast where someone from one of the companies, I'm sorry, I don't remember, was being asked this sort of the same question, like, will this be as revolutionary as kind of the app store and the associated technologies, and will we get kind of fart apps or will we get Uber? And his response was, we'll get both. Right. And so sometimes we start out with the silly or the, degenerate or whatever. And then someone comes up with some new business model that's only been made possible. I mean, that wasn't just a particular application, that was an entirely new kind of platform business model. And I think we'll see that. And I think we can, and I think it was an underlying kind of mournful note in that hearing, which was that we, Congress, messed up digital regulation. We didn't do anything. We were very optimistic. We didn't anticipate some of the harms. Let's not make that mistake again. So I think we're in a very different posture than we were. I mean, he talked about 1998. I think we could go back to 1996, right, with the start of internet regulation.
And before we get to his second question, but since you mentioned it, right, that is a fundamental debate. The internet was not heavily regulated, but many people would say good, particularly in its early days, because it allowed the private sector to develop all the technologies that we enjoy today. And so that is a debate right now amongst technology scholars and amongst policymakers, at least to some degree, which is the question of how aggressively this new technology with all of its unknowns should be regulated. Now, I think implicit in your answers is that we need to regulate, but I'm curious if you think there's any merit to that pushback point, that notwithstanding what we have learned about the downsides of the internet, that we benefited from, we being society benefited from Congress not acting and regulators not acting in those early days and years, which we are clearly in now with AI.
Yeah, there's huge merit to that argument. And nor was it obvious. The regulatory proposals in the early days of the internet were not great. There were other, I think moments when there could have been, I think, some sensible regulatory intervention, especially sort of in the competition domains. These entities were allowed to grow very big, very fast without any kind of concomitant regulatory obligation. That might have been a mistake. And today, of course, it's a balance. I think some of the interesting proposals I've heard, have to do, and we know a lot more now about cybersecurity, right? We know a lot more about the whole stack, the hardware, the compute, especially these highly capable systems. And I know we haven't really talked about generative AI yet, but I think there are ways to kind of slice the ecosystem a little bit differently than there was, at least in the early days of the internet. And if we remember back to then, nobody was very big. The big entities were the telcos, right? And the telcos and the cable companies that were regulated by the FCC, but everybody else in the ecosystem was small to begin with. And then by the time they got large, by the time we had, Meta, Facebook, Google, we were already in an absolutely sort of deregulatory status quo. So I think it's sort of those pivot points that we want to look at now. And but yes, there is merit to those arguments, and there just has to be, I think, some counterweight given the lessons that we've learned.
Right, which I think is baked into, and I want to play the second question, or not statement and question that Senator Durbin made in this hearing a couple of weeks ago.
But the very basic question we face is whether or not the issue of AI is a quantitative change in technology or a qualitative change. The suggestions that I've heard from experts in the field suggest it's qualitative.
So that sounds even more theoretical, qualitative versus quantitative, but I'm curious what your take is on that one.
Can I challenge the premise?
Yeah, please, to reject the question, sure.
Yeah, I mean, because we've heard the expression disinformation at scale, right? So, scale, and there's the Supreme Court's Carpenter case has this famous line, digital is different, right? So that when at a certain point, quantitative differences are qualitative differences, that if you can create, synthetic media, and that's what virality is about, right? And it goes viral. Is it qualitatively different from, a gorgeous piece of synthetic media that we might share right now on this podcast? No, it might be the exact same one, but the scale makes it different. And I think what we're seeing that the quality, if we just look at ChatGPT output, right? It's qualitatively different in that it's generative and predictive, and it's not like search, in that it's not necessarily tethering information to a particular source. It's also maybe qualitatively different in the authoritative voice that it has, and we can find some qualitative differences, but it's really also just quantitatively different from a Wikipedia response, because of how many people are using it, who it's serving.
Right. And so let's talk about that now in the remaining about 15, 20 minutes that we have. Generative AI, as the name implies, right, is generating content. And the general working definition that I use is exactly that it's artificial intelligence that creates new content. Simple. Too simple?
No, I think that's right. And it can, based on statistical predictions of what's likely, it can create all kinds of, we know about images and text and music. It can also create new data, right? So generate, we also know about its mixed record on its numeracy, right? And creating, solving math problems, creating answers to math problems and code, but also, immersive experiences, websites, video games, any kind of information it can generate.
It is remarkable, and I want to use what is a funny to the outside world but sad story, which just came out a couple of days ago, in an opinion from the Second Circuit district courts, the federal courts, where a court is more or less considering sanctioning an attorney who used ChatGPT. And I'm not going to, there's no reason to name the case or the individual, because while it's an egregious error, that's part of the question. So this for those that aren't familiar, the lawyer used ChatGPT to write a brief, a paper to the court. And in that paper to the court, ChatGPT apparently made up citations, cases that did not exist, to support the legal arguments. Now, without getting into, I don't even want to talk about the ethics issues and everything else. And it may turn out that there's some other story here, but let's go with the premise. One of the big issues that raises, which we've already alluded to, and you've already described, Ellen, is that ChatGPT and other generative AI, at least right now, are not search engines, and they are not gathering facts from the internet, but rather predicting the next word in these predictive models that we discussed at length with James Grillerman a few weeks ago to create content. That, to me, is a wholly different animal than any previous technology that we've seen, because the internet doesn't create, right? The internet is, famously, late Senator Stevens called it a series of tubes, which as a analogy is not that bad, by the way. But the point is, this creates. So from that perspective, right, lawyers getting fooled. I have a bunch of questions. I'm going to start here, which is education. One of the roles of regulation here can be educating. I mean, these are attorneys, right? What do you make of that? What do you make of the events that I'm describing, right, assuming it's accurate? And what do you make of the educational role here that the government, the NTIA, that these discussions can play? Because it's huge.
Yeah, I agree with you. So let's starting with the lawyer. And a judge in the Northern District of Texas has now issued a protocol for lawyers that they must certify that their filings have not been generated by AI, or if they have, that they've been checked by a human, which I find a little curious, because the Lexis and Westlaw databases are all incorporating GPT technology, and we lawyers all rely. I mean, they will be much more accurate, I think, than just a unmediated ChatGPT experience. But we don't check those. We don't go back to the volumes to check what Lexis tells us. But I think what's interesting about the courtroom context is that there, the standards for sort of truth, accuracy are very high. And there is a judge, right? There's someone who is going to hold you, the lawyer, accountable for being having some ground truth. And now that story could have turned out very differently. Maybe the judge would have been persuaded and not have checked it. And so I'm not saying it's not a problem, but I'm saying the special context, as in so many cases, right? The special context of a court where truth is valued and is refereed, sort of casts a light on how the rest of the world is totally not like that, right? So in most contexts, we don't even have to talk about how inundated teachers will be trying to untangle this, and of course that's another conversation. We're both teachers, and I'm sure we're both thinking about that. Yeah. But yeah, so outside that context, I think that's one of the chief risks right now, is that there's going to be mis and disinformation and deception and synthetic media, and it will be very hard to determine what's true, and there will be no judge sort of refereeing that.
And which is, by the way, why Hearsay Culture was named as it was in 2006 by me, right? That the internet was going to create these challenges of determining truth from fiction. And I was just thinking of the internet. I wasn't thinking about generative AI. So we've got this questionable use. We've got this lack of understanding. And now we can add on, and I want to cover a few issues here in the remaining time we have, right? The concern that many have raised that while we could get and have already gotten some amazingly interesting content, we've also have an enormous risk of misinformation, and we're coming into an election year next year, and already it's not really extending much or creating a tremendous amount of wisdom to suggest that nefarious actors might use this technology to mislead. What is the role of regulation, and what do you see regulation as capable of doing to deal with that problem before we get to some of the positives?
This is really hard, right? Like we know, at least in the US, that there's not much regulation can do when it comes to content. And that includes, now there's more that regulation can do when it comes to electoral content. And there are kind of rules, guardrails about mis and disinformation when it comes to polling places and hours of operation and those kinds of things. But there's very little regulation, nor can there be, about misinformation in political ads. That's been true forever, right? And that was true on the internet, and that's true with AI. I think, it's more profitable to look at sort of structural guardrails that can be put into place that give people, to your point, more understanding, education, and especially provenance of where information comes from. So that I do think is possible. And so I think whether it's through self-regulation and convening stakeholders and kind of encouraging there to be uniform standards about how to watermark content, how to make sort of the source of information clearer. That could be through footnotes, that could be through watermarks. Education, and one thing I will point to that I think is a really interesting development is when OpenAI released ChatGPT-4, it also has a very kind of wonky 100-page system card, or I think they call it system card, some people call it model card. And it really describes how the system operates, what it's capable of doing, how it hallucinates, how they try to train it out of hallucinating or having hate speech or their values. And that I think chiefly serves an educational function. Now, nobody, the average person's not going to read it. And so there's a role there, and whether this is a regulatory function or a sort of convening, supporting function, there's a lot of work to be done on sort of the nutritional label side about how to communicate what is high quality, high integrity information and what's garbage.
I do want to use that word hallucination advisedly. That is a word that technologists have been using for a bit of time, but of course it's well known now. And what hallucinating is, I want to put it this way, hallucinating is making stuff up that isn't true, more or less. I mean, the example that I used with James a few weeks ago is consistently when I've asked ChatGPT to write my biography as Professor David Levine. Professor David Levine consistently graduated from Yale Law School and clerked for a variety of federal appellate judges, neither of which are true, but both of which are typical of law professors, both graduating from Yale and also clerking. Isn't hallucination a nice term for making stuff up? And if so, why are we using it?
Good point. And I'm not wed to it. You're right. I use it because they use it, and it's a pretty word.
Right.
Yeah, it's making stuff up. I don't think it's lying, right? Because it doesn't have the intent, but right.
Well, and so this is what it gets to. And now it's also contracts professor time. Words matter, right? Words matter. How we label things matter. We've had that discussion in the context of the internet in any number of ways. I think a terrific example is hacker, right? Hacker has a colloquial meaning of something bad. And then Oliver Day and Derek Bambauer wrote an article now about 10 years ago about the term hacker. And they basically pointed out that it's misleading in the sense that there are good hackers and bad hackers. So, right. But if we talk about hallucinating, right? It kind of has this mystical, oh, we all kind of occasionally make things up concept. Maybe it also goes in direction of illegal drugs and things like that. But the point is, right, it doesn't sound as bad as I made that up and told it to you and made it appear true. And if we frame it that way, again, I agree with lying has an intent aspect to it, although colloquially, I think people call it lying. But the point is, doesn't that matter from a regulatory standpoint in the sense that you and I might understand hallucinating, right, in what it means technologically, but most people who are not in the weeds of this are, oh, we all hallucinate from time to time.
Yeah, I mean, so and I think, the maybe why they use the term hallucinate is that it is a particular subset of making things up. I think we could use the term stereotyping, right? They are stereotyping you as a law professor. It wasn't particularly negative, although it could be, right? And from a regulatory perspective, one could imagine maybe there should be a standard, a particular metric you have to meet for accuracy. The problem is, how would you define that in a sort of First Amendment friendly way? Obviously, we have defamation claims, and Eugene Volokh has written a lot about this. When there's a hallucination that is defamation, and I don't know if I didn't hear the conversation with Grimmelman, but I'm sure you talked about Section 230 and whether that would apply. Most people think it wouldn't. So that action could go through. You could also imagine a kind of consumer protection enforcement of consumer protection law, to the extent that a system was claiming that it did not hallucinate or it provided accurate results, and you could show that it didn't a significant number of times, then I think there could be enforcement of that. I just think the problem is under existing, and this might all change, right? Like, we have these net choice cases that the Supreme Court is likely to take, right? Which are going to, since it didn't take up Section 230 or content moderation in the previous cases that it decided on Section 230. Most people think it will take this up. And, I just think, so maybe we'll have new First Amendment law. But right now, it is hard to think of a regulation that would pass First Amendment muster that would require large language models to be accurate and define accuracy a certain percentage of the time.
In the last few minutes we have, so you mentioned the EU. So the EU is heavily considering and moving forward on something called the AI Act. Well, obviously, we're not going to get into the weeds of it here, but top level, they're attempting to regulate artificial intelligence based upon harms, which is also how privacy has been conceived as a way to be regulated. What kind of harms are associated with privacy violations, and they're doing the same thing here. Again, I know I'm simplifying it greatly, but for purposes of the question, so there are some AIs, like AIs that would start World War III, that are prohibited. You can't do it. And then you've got this middle ground of AIs that might have some legal issues, and there's all these different ways to regulate it. Again, the details aren't important. Here's the question: is that a good way for the public to think about its interaction with AI? Because AI is already becoming ubiquitous. We already see various platforms integrating it. It's hard to envision that it's not going to go in that direction. The public encountering this, however, right, may not know what they're dealing with at a given moment. Do you think that explaining technology, teaching technology based upon its harms, right, and so you understand the risks, is a good approach, not only from a regulatory standpoint, but from an educational standpoint?
I think the EU AI Act is pretty good. I don't think it necessarily works in the US. And the reason, what I think it accomplishes, first of all, one of its provisions is it would tell you if an AI is being used on you. So if you apply for a job and you don't get it, and they're using an algorithmic system to rank you, you're entitled to know that. And then, I think that's considered a high risk area. And so you also know that at least that someone in government took a look at that. And at least the company self-attested that it had evaluated that system, and it had determined it was fair and complied with the law. So if that's all it does, it's some sense that you're not living in this complete Wild West with these systems that you don't even know if they're in use. You don't know, they're not explained to you, they're opaque. You don't know that anyone has assessed them for lawfulness or safety. So at least it gives people some assurance. I'm not saying it's, perfectly effective, but some assurance that there's been some check.
So in the last couple of minutes here, Ellen, it would be negligence if I didn't ask you. So where are we right now, and what can we expect from the NTIA in terms of how going forward on May 31st, 2023, what can we see coming from our government?
All right, so I should say there is the federal government, the Biden administration is a beehive of activity on AI. So we're just a piece of this sort of all of government effort. And so, yeah, there's not enough time to get into, every agency has a piece of this. There are interagency collaborations on all kinds of aspects of AI, both on the opportunity side and on the risk side. For our part, we have this request for comment. It's been out for a couple of weeks. It closes on June 12th. And then we are going to work very quickly to assimilate all those comments. We've asked 34 questions, and they all go to this accountability policy, which in a nutshell is how do you developers and deployers of AI prove to the public, to regulators, to other businesses that you're trustworthy? And that's been defined by lots of entities, government entities included. How can they be assured that they are getting what they expect, which is AI that is safe or accurate, whatever the aspect of trustworthiness you're interested in. And so we're looking, and we hope we will be able to propose policies that kind of sort of help with audits, third-party independent audits, looking, how do we know that a business's balance sheet is what they say it is? We have a system of auditing and assurance. How do we get that for AI, including the questions that were raised or the recommendations that were made that Sam Altman made from OpenAI at that hearing? Maybe some systems need to go through a licensing procedure or a certification procedure, which is about assuring that they're safe. So we ask all those questions. We're hoping to have, reasonably actionable recommendations, and that will be in the fall.
And to be clear, anyone can offer input. Right? You don't need permission from the NTIA, and you can go to ntia.gov to get that information.
Right.
Ellen Goodman, Senior Advisor, National Telecommunications and Information Administration. As you said, beehive of activity, busy time for you, to put it mildly. And so I am grateful that you've joined us today on Hearsay Culture and the Hearsay Culture Network. Best of luck working through these challenging issues, and I look forward to future discussions.
Thanks, Dave.